A deposition is the out-of-court sworn testimony of a witness that is recorded by a court reporter for later use in court or for discovery purposes. Depositions are part of the discovery process in which parties to a lawsuit gather information in preparation for trial. The primary reason that the opposing attorney will seek your deposition is to hear your story and to pin you down to that story. In other words, the opposing attorney wants to commit you under oath to your story. And should you try to change your story during your trial testimony, the opposing attorney will attempt to discredit you as a witness by impeaching you with your own sworn deposition testimony.
You may proceed.
Tell the court why you were outside your husband's driveway at midnight on the night in question.
I had lost my necklace at some point, and since I had been at his house earlier, I thought it might have come off somewhere in his driveway.
Ma'am, isn't it actually true that the reason why you were in his driveway at midnight is because you wanted to see who was leaving his house?
No, that's not true. I was just looking for my necklace.
May I approach the witness, Your Honor?
You may.
Do you recall that I took your deposition several months ago?
I do.
I'm going to hand you a document and ask you if you recognize this document to be the official transcript of your deposition.
It does appear to be that, yes.
Please turn to page 25 of your deposition and refer to line 5. Please read line 5 through 25 to yourself. Now that you've had the opportunity to review this portion of your deposition, do you wish to change your testimony?
I guess I did say at my deposition that I was waiting outside my husband's house to see who left. But I was also looking for my necklace.
As just illustrated, when the opposing attorney was impeaching the witness with her own deposition, the opposing attorney was also hoping to catch the witness in a lie, thereby showing the judge or jury that the witness is not a truthful person and the witness's testimony should not be considered credible, particularly on points that are crucial to the case. Taking your deposition will also assist the opposing party as well as your own attorney in evaluating your case for settlement purposes. Therefore, it is very important that you answer all questions in an honest and straightforward manner. Now that you understand why your deposition is being taken and the effect your deposition may have on later litigation, let's look at what's going to happen during your deposition. Depositions are often videotaped for future viewing by a judge or jury. Therefore, your first concern should be your appearance. Conservative business attire is proper dress for court and depositions. If you're uncertain what to wear, talk to your attorney. Inappropriate attire at a deposition may later create a negative impression on the judge or jury. Appropriate attire tells the judge or jury that you're serious about your case and creates an impression of you as a responsible person. Your deposition will begin with your oath that your testimony will be truthful.
Raise your right hand. State your full name.
John Lewis Clark.
Do you swear to tell the truth, the entire truth, and nothing but the truth?
I do.
Your deposition will likely begin with introductory information about yourself. Remember that your deposition will be taken under oath. It is essential that you be truthful in everything you say in answering the questions during your deposition. If there is an area with which you are uneasy, talk to your lawyer prior to the taking of your deposition about those areas of discussion.
Have you dated any women besides your spouse since the day of marriage?
No, never.
I'm going to hand you what is marked Exhibit A and ask if you can identify this photograph.
Yes, it appears to be a photo of me and a woman walking into a hotel room.
As you can see, when caught being untruthful, the situation can slide downhill rather quickly. Let's observe the correct way to handle this testimony.
Have you dated any women besides your spouse since the day of marriage?
Yes, actually I have.
Who have you dated?
Well, I've had several dates with one woman in particular.
Telling the truth, while difficult, is much better than being caught in the middle of a lie in your deposition. During the course of your deposition, the opposing attorney may ask you questions that are the same or similar to questions that you've already responded to during the written discovery process. If you have previously responded to discovery, it is important to review your written responses prior to your deposition. Recall that one of the purposes of the deposition may be to attempt to trap you into an untruthful response. Unless there is a valid reason for your answer to change, be prepared to respond to your deposition questions in the same manner as your discovery questions. Failure to be familiar with your discovery responses may lead to an uncomfortable situation.
Have you ever discussed with anyone the allegations you have made in this case?
No, I don't think so.
In looking at your answers to interrogatories, you stated that you explained all of your allegations to a counselor. Is that correct?
Well, I'm not sure.
In that scene, the party being deposed was clearly caught off guard because he did not recall his prior interrogatory responses. Let's look at the same scene, assuming that he had reviewed his responses.
Have you ever discussed with anyone the allegations you have made in this case?
Yes, I have. I mentioned the allegations to my counselor.
Just like your appearance, your behavior at your deposition will create an impression on the judge or jury as to your priorities as a spouse, parent, or other party to family law litigation. Do not joke during your deposition. Your case is a serious matter. If you laugh during your deposition, it will make you seem somewhat arrogant and/or not serious about your case. Treat the deposition seriously and with respect. Don't volunteer facts. Answer only those questions asked and do not provide any further explanation.
State your name for the record.
My name is Judith M. Clark.
That was an appropriate response. The following is an example of an inappropriate response.
State your name for the record.
My name is Judith M. Clark. My middle name is Marie. My friends in high school called me Mary, but I'm thinking about changing my nickname to Judy.
If you start volunteering answers, you'll find that the opposing attorney will allow you to go on, as your volunteering of information can only help the other side gain more knowledge about your case.
Did you take your daughter to the park?
Yes.
Did you take your daughter to the park?
I took our daughter to the park. We stopped and got ice cream, and then we went to the mall.
You said you stopped and got ice cream. Ms. Clark, do you recall the judge's order where neither party was supposed to feed sweets to your daughter due to her medical condition?
As you can see, Ms. Clark was merely asked if she took her daughter to the park. However, she proceeded to provide additional commentary that was not asked of her, and as a result, she has made an admission that may harm her case. Don't argue with the attorney that is asking you questions at your deposition. Although you may feel that the attorney is being argumentative or the question is unfair, answer it with straightforwardness and respect. Your calm and respectful behavior in the face of controversy will reflect positively upon you as a witness.
Why exactly did you go to her house that night?
I went to the house to pick up my daughter.
Oh, so you just happened to be coming to the house to pick up your daughter. And what time did you arrive, Mr. Clark?
I arrived at 6 p.m.
The party being deposed handled those questions with a calm demeanor, and the opposing attorney's attempts to get a rise out of him were not successful. Let's look at the alternative.
Why exactly did you go to her house that night?
What kind of question is that? Of course, I went to the house at 6 to pick up my daughter. Why do you think I went to the house? You think I was just driving around looking for something to do? Do you think I have nothing better to do than to go drive by my ex-spouse's house?
Not only did the questioning attorney manage to bait the party being deposed into an argument, but he came very close to losing his temper. Never lose your temper during your deposition. Always maintain a level of calm.
It appears that you spent $10,000 on unnecessary expenses. Is that correct?
Well, I think the expenditures were reasonable under the circumstances.
It appears that you spent $10,000 on unnecessary expenses. Is that correct?
Well, if you ask my wife, every penny that I spend is unreasonable, but I think my expenditures were very reasonable under the circumstances. I've spent other monies as well.
Clearly, Mr. Clark would have been much better off having not made that final remark, but he let his temper get the best of him. Mr. Clark's response demonstrates that if you lose your temper, you will generally say things that you would not say otherwise. Stay calm and do not lose your temper under any circumstance. Never guess at your answer. If you don't know the answer, then simply state you do not know.
How much do you think the marital home is worth?
I'm not sure. If I had to guess, I'd say somewhere between $50,000 and $250,000.
How much do you think the marital home is worth?
I don't know.
To guess at an answer can certainly hurt your case. Keep your answer simple. If you do not know, simply state you do not know the answer to the question, no matter what it is. Take your time in responding. There's no need to feel hurried.
I went to go pick up my daughter from daycare and she wasn't there. The daycare worker said that my husband had already picked her up. I got really angry. I jumped in my car and I went to go find them because it was my time to have possession of her. I went to pick up my daughter at daycare and she wasn't there. The daycare worker said that my husband had already picked her up.
When you're answering a question, do not attempt to explain or justify your answer. Remember that you are offering the facts as you understand them. Give short and concise answers and answer only the questions asked.
Why did you go to the store?
To buy a carton of milk.
As you can see, the attorney asked a simple question, and the party being deposed offered a simple and short answer, answering only the question asked.
Why did you go to the store?
To get a carton of milk. I thought about getting some bread too, and then I thought about pretzels, which got me into the beer aisle, and I saw all the 12 packs, but I was way more impressed by the case prices. Well, then I thought, I'm going to get some wine, but I'm not a huge wine guy.
You may be tempted to bring your notes or other documents you want to use for reference or to refresh your memory during your deposition. Keep in mind that any document that you review during the process of your deposition is subject to inspection by the attorney that is deposing you. Therefore, during your deposition, you should never refer to any documents unless you are absolutely certain those documents can be inspected by the opposing attorney. Always ask your attorney prior to the deposition about what documents you may review during the deposition, as you cannot confer with your attorney during the deposition.
What is the name of the person who witnessed this event?
I'm not sure. Can I check my notes?
Sure. Go right ahead.
Let me see here. Yes, the name of the witness is Sally Jones.
Did that notepad help refresh your memory?
Yes, it did. Thank you.
Since you used that notebook to refresh your memory, I would ask that you turn that notebook over to us for review.
I mean, it has my personal notes on it. Aren't those confidential?
As you can see, Mr. Clark's innocent reference to his personal notes resulted in the entire notebook being turned over to the opposing counsel. There are a few additional things that might help you to better understand and cope with the deposition process. Unlike actual litigation in a courtroom, your lawyer's ability to object to questions asked to you during your deposition is very limited. Indeed, your lawyer is generally limited to 3 types of objections that must be stated in a very specific way. Don't feel that your lawyer is not defending you against the opposing attorney, as he or she might readily do in the courtroom, as your lawyer is very limited in those responses that are available. The idea behind this rule is to allow the open, free, and timely conveyance of information. There is no judge at your deposition to rule on the objections. Therefore, once your lawyer has objected, unless you are otherwise instructed by your lawyer not to answer the question, you must go ahead and answer the question. Your lawyer's objections may be lodged later in front of a judge before that portion of your answer is read into the court's record. This means that some of the answers that you give at your deposition may otherwise be inadmissible in a court of law.
Isn't it true that your daughter told you that she wanted to live with her father?
Objection form.
When your lawyer objects, do not say anything further until you are instructed by your lawyer to do so.
Go ahead and answer the question.
Well,
Under
she
rare
said that
circumstances,
she did want to
your
live
lawyer may
but only
instruct
because
you
he has
not to
sworn.
answer the question. Always follow your lawyer's instructions in this regard.
When you discovered that your daughter wasn't in daycare, did your attorney give you any instruction?
Objection form. I am instructing my client not to answer that question.
Please explain.
That question calls for an answer that falls within the attorney-client privilege.
You are not allowed to confer with your lawyer during the deposition, nor can your lawyer whisper in your ear to assist you in responding. If your lawyer feels there is a necessity of conferring during the deposition, then he or she may ask for a conference. There are only a limited number of conferences available during the deposition. Let's review what we've discussed and add a few more hints that will help you to have a smoother and less stressful deposition. Dress appropriately for your deposition. Remember that you may be on video for the judge or jury to see later. Listen to the question asked and make sure you hear and understand the question before you attempt to give an answer. Take your time. Don't worry about silence. When you do answer, speak slowly and clearly and do not volunteer information. Never joke or laugh inappropriately during your deposition, and don't attempt to outwit or argue with the opposing counsel, nor should you ever lose your temper during your deposition. Limit your testimony. Don't guess or give estimates in your answers, and never attempt to explain or justify your answer. Remember, you are only there to give the information you have readily available. Don't divulge what your lawyer has told you, as this information falls within the attorney-client privilege. Don't refer to documents during your deposition unless you've already discussed this with your attorney. After your deposition is ended, the court reporter will transcribe the deposition and place it in the form of a transcript that should contain all of the questions and answers verbatim. You'll be given a specific period of time to review the transcript and make a notation on a special page provided at the back of the transcript of any changes or corrections. This transcript and your corrections or changes, if any, will become the official transcript of your deposition, and the admissible portions of the transcript may be used at later litigation in your case. Of course, it's impossible to cover every event that might occur during your deposition. However, we hope that the short skits that we've shown and the tips given will at least help you get started towards proper behavior and appearance during your deposition. The Family Law section of the State Bar of Texas understands that no family law litigation is pleasant or easy. We hope that by presenting the advice and suggestions contained in this video, we have at least made the process easier to deal with.